Good afternoon, I'm Stacy Pate, and today I'm going to be discussing with you the Fourth Amendment to the United States Constitution. The Fourth Amendment specifically states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment is surrounded in controversy, and there are multiple Supreme Court cases from the inception of the Fourth Amendment through today that focus on the right to individual privacy. The Fourth Amendment does not guarantee protection from all searches and seizures, but only those that are deemed unreasonable, and that is left up to the interpretation of the judicial branch. And so courts are allowed to determine what they consider to be unreasonable search and seizures. Most warrantless searches of private property are prohibited by the Fourth Amendment unless specific exceptions apply, such as giving consent to an officer, probable cause, if people are in immediate danger, and if objects seized are in plain view. Under the exclusionary rule, improperly obtained evidence, no matter how telling the evidence is, cannot be used by prosecutors. The exclusionary rule was first established to prevent the federal government from using improperly seized items against individuals in federal court. However, it has now been extended to the states as well through the United States Supreme Court of Mapp v. Ohio in 1961. In recent decades, the Supreme Court has diminished the scope of the exclusionary rule by creating exceptions. The court has ruled that if officers are acting in good faith and they have the wrong warrant but yet seize evidence, that evidence can be admissible in the courtroom. Also, we've seen a lot of questions about the validity and the constitutionality of the 2001 U.S. Patriot Act passed by the Bush administration. The Patriot Act gave the federal government the right to search telecommunication records, library records. The act had good intent. It was intended to try and protect our nation against terrorist threats. However, there have been some questions raised as to whether or not the federal government's ability to search and seize property without a specific warrant is a violation of the Fourth Amendment right to privacy. In 2015, the U.S. Patriot Act did expire. However, there was a new piece of legislation passed called the USA Freedom Act, which essentially reestablished the basis of the Patriot Act. And so we continue from its inception through today to see questions about what constitutes privacy and whether or not there is a right of the government to violate privacy in the name of national security. Thank you.